For the quarter of sentencing, I have one final question for you. I'd like to answer it. Are you amenable to participation in the restorative justice process leading to the
What is restorative justice?
So a restorative justice corrective order is a panel typically convened by the Community Justice Center, in this case, where the community actually runs the Social Justice and Restorative Justice Center in Newport. What that entails is typically talking to a panel about the nature of the offense behavior and the impact of the community and making a plan to address any harm that's flowing from the offense. So again, I know in this case it's not a definitive appeal, it's typically something where someone would be guilty that can be considered, the state did ask for it, but I don't want to refer you to that as part of any sentence outcome if you are not amenable and do not want to participate in that process.
So a panel that you speak at, so you're saying it's a little confusing. So it's like people in the community.
Right. So it's like a group, there's some 8 employees, and then typically a record board will be comprised of community members who on a volunteer basis sit and kind of work with you to come up with a plan to address any harm that has occurred based upon the offenses. That typically does require some acknowledgement or admission that you did something wrong, maybe not criminally wrong, but some acknowledgement of wrong. And I don't want to put you on the spot. I know you don't believe you did anything wrong here, and you wrote the defendant. But that said, those are requests the state made, and I don't want to add that on. It is going to just set you up for failure and not wanting to sit around and do it. So I only want to understand if you want to amend that type of condition or outcome, or whether that's just not something you're interested in.
Let's say that at this time that would cause a huge inconvenience. I have years of catching up on to kids with my businesses. I have a lot of great opportunities right now. That would be the biggest reason that I would not want to participate in something like that.
All right, thank you. I just want to make sure you could see whether that was on the background. One statute requires the court to consider a number of factors under the law before imposing a sentence. There are also some common law factors set forth by case law provided by the Supreme Court. Starting with the statutory factors, 13 VSA section 7030 requires the court to consider the nature and circumstances of the crime, the history and character of the defendant, the defendant's family circumstances and relationships, the impact of any sentence upon the defendant's minor children, the need for treatment, any non-compliance with court orders, or failure to appear in connection with criminal prosecution, and the risk to self, others, and the community at large presented by the defendant. The common law factors adopted by the Supreme Court that are relevant to consideration are as follows. They include punishment, specific deterrence, general deterrence, and the need for rehabilitation, among others. Applying these statutory and case law factors to the current case, the court made the following observations. First, the court views the totality of the conduct here and criminal offenses to have been the unfortunate consequence of having multiple opportunities to stop what was occurring. As we heard during trial testimony, there were multiple times all DCFs were looking for some form of engagement in order to ascertain whether or not 2 of your children were or were not enrolled in a home study program or had some alternative plans for education. We need not all love or like what DCF does, but they have important statutory functions, including the role in ensuring that all children in the state of Vermont have access to or gaining some valuable education, whether that's in a homeschool setting, private school setting, or in a public school. The record before the court was there were multiple times of DCF first attempting letters, phone calls, stopping at the residence. Each time they were met with non-cooperation. That non-cooperation ultimately led to the initiation of a collateral matter in a family division to again ascertain whether or not the children were in need of supervision based upon the inability to verify their access to education. We heard it during the course of the trial that law enforcement made multiple efforts to serve or inform Ms. Bourdeau of the legal proceedings. That did not come to pass, and ultimately, when the case was filed, she did not appear in court or make any contact resulting in a juvenile pickup order being issued. That order was not an order that would have even temporarily or permanently deprived Bourdeau custody of the children. Rather, it was an order that would hail them to appear in court to address and move on with the case. That was the final and probably best opportunity to stop the proceedings by agreeing to cooperate and provide proof of educational opportunity to both of those children. And the governor, as everyone is aware, as we heard during the trial, the case escalated where an emergency custody order was issued based upon uncertainty about the initial or their status. Again, this all stems from multiple decisions of the defendant not to cooperate with either DCF, law enforcement, or with the courts. So from that sense, I started looking at sentencing as this is all a situation that could have been avoided. What occurred 3 years ago, just outside here on the road, all could have been avoided by just simply having a conversation with any one of the individuals that were looking for that information beforehand. I understand fully that a parent may be scared, especially one is skeptical of government, the intentions of DCF, are concerned about what they've seen and heard on the news about abuses of children in state custody or in child protective systems. That is all understandable fear. But at some point in time, that fear became unreasonable. And it led to the court decision. While I can't speak to every individual case, seldom is there an opportunity or circumstance where educational neglect of a child will lead to the extraordinary act of a court taking children from their parent on a temporary or permanent basis. Again, that may not be known to the layperson in the state of Vermont, but to the DCF workers, to the law enforcement officials, and the court personnel, prosecutors involved, it all seemed to be a substantial overreaction in non-engagement, given that all that anyone was looking for was verification of school attendance or education plan. That culminated again here just 3 years ago with the children being taken away from the courthouse before they could appear before a judge consistent with the order. I'm not going to rehash what the jurors' findings were. The jurors found Eunice Bourdeau guilty of full obstruction and impeding law enforcement under the circumstances, having dismissed the defense's raised that you were motivated by fear, not by willful design or intent to obstruct or impede the due administration of justice or to impede the officer effectuating that order. With all that said, the nature and circumstances of the crime have to be taken in the overall context. I don't question, as the sentencing judge here, that you were fearful, that you were skeptical, that you were distrustful of DCF and of law enforcement and others. That is perhaps a natural reaction of a parent, especially in your circumstances. The remainder of the factors here largely fall in favor of Eunice Bourdeau. The court is cognizant that this case began, as pointed out by some of your witnesses today, as a child protective proceeding concerned about the educational access and welfare of the children. The state is not asking for any direct incarceration sentence, I think, and the acknowledgement that the court is not considering a further incarceration today, quite frankly, because the net benefit of depriving you of liberty is far outweighed by the collateral impact on children and on your family, especially your youngest child. The questions here and the recommendations from the state centers on need for treatment. And this is where opinions may differ. I tend to agree with Attorney Piper that a civics class or liberal political things might be for very much like that. I don't think you actually subscribe to or believe in those things. I'd love to say that the community does efforts in rehabilitation or making events when it occurs. But in terms of need for treatment, I can't buy that you pose a general threat to society, that you pose a threat to the community at large, and you present a risk to others or yourself. Rather, this is functionally a case that centers on poor decision making, not criminogenic propensities or desire to directly harm or cause violence upon others. terms of non-compliance with orders of failure to appear, the record will direct you to appear at court hearings, and even if you've had time to struggle to follow the court's guidance, it's not something that can be held against you, nor would I want to hold against you. Looking at the other sentencing factors of the common law, in terms of rehabilitation, general, specific deterrence, and likewise punishment, court doesn't apply punishment at this point to be a particularly compelling avenue, given the collateral consequences of a felony conviction are substantial. Those convictions may impact your ability to work, to be employed, to receive, or have access to certain state or federal benefits. So there will be forever a record at this point in time of the crimes that occurred. In terms of specific and general deterrence, the court is mindful that there may be arguments for general deterrence that the state is certainly arguing to take that parents should be on notice that disobedience to DCF or court orders when child welfare is involved is going to be dealt with severely and substantially under the law. I think that they would accomplish that by following through on this prosecution, and the conviction itself is a deterrent. The need for additional punishment or jail time as part of the text really doesn't make sense to this court. In terms of specific deterrence, I believe every word you have said and what all of your support persons have said. This has been an unfortunate, traumatic, and unpleasant experience for you. I can't sit here and convince you of the propriety of the court or address each and every one of misplaced jurisdictional arguments. But that's really secondary to the point that ultimately what they presented is that this has had an impact on you in a very negative impact. As you've indicated, it's impacted your family relationships, your standing in the community, your businesses, and your ability to manage your farm. So I think there's already been a substantial amount of deterrence for you personally in terms of how you proceed moving forward. And if not, then you certainly are aware of what the consequences are for going down this path again if there is future issues concerning the court process or orders or DCF involved, which I hope does not occur. In terms of rehabilitation, again, we've covered that there. Aside from this incident, nothing to say that there's general propensities towards criminal behavior, violence, anything along those lines. So in terms of rehabilitation, health counselor record for their limited utility. All that having been said, I do find it incredibly compelling what each of these witnesses have said today in their threats and letters. We're not here to judge whether you are or are not a good mother. We're not here to decide whether you are a good person or a bad person, or whether your beliefs are consistent with the law or not. None of that is really at issue. It's only whether or not there's what the adequate response to these behaviors. One thing I will say, though, is your other pro-social tendencies of loving your family, caring for them, and quite frankly, being committed to being part of the community are all things that we reflect well, even if we disagree, even if we question the jurisdiction or authority. All that having been said, on balance, most of these factors, with the exception of the school style, weigh in your favor. To that end, the court's review of the history indicates that Ms. Bourdeau had 3 days of credit in these documents based upon her arrest on the warrant on September 2nd, 2022, and her release at approximately 3:30 in the afternoon on the 5th of September, 2022. With that in mind, the count one, the court sentences the defendant to 2 to 3 days to serve credit as allowed for by law. The court will also adjudge a $2,500 fine. As to count 2 to 3 days to serve concurrent with credit as allowed for by law. Effectively, the sentence is credit as allowed for by law with a $2,500 fine payable to the court. Ms. Bourdeau, these paperwork you can fill out as errors concerning payment of the fine, otherwise these proceedings are. I wish you good luck with the board, and I do think sincerely that this brings to a close a very negative and unfortunate chapter.
All rise.